Welcome back to America's Fractured Politics. Imagine it's November 2026. The polls have been closed for hours. Cable news is cycling through the same handful of counties, the same breathless too close to call graphics, the same anchors insisting that democracy is working as intended. And yet, no matter how many precincts report, no matter how many ballots are scanned, the basic shape of the result was locked in months, really years earlier, in a quiet marble building in Washington, where a Republican-engineered Supreme Court decided which lines on which maps were legal and which ballots arriving in which mailrooms would count as votes or as trash. That's the story we're going to tell today. Not the story you see on election night with the choreographed drama and the red-blue maps. The real story: how a court stacked by Republicans and relentlessly lobbied by Republican lawyers has turned itself into the most important election board in America, deciding who votes, which votes count, and who gets to pick the next Speaker of the House before a single voter ever fills in a bubble. Because this week, that court did two things that, taken together, tell you almost everything about where American democracy actually lives now. First, it quietly let California use a new congressional map that Republicans are already screaming is unfair, even as they lock in brutally rigged maps of the states they control. Second, it moved closer to deciding whether millions of mail-in ballots, including those from military and overseas voters, will still count if they arrive a few days after Election Day, in a case brought and driven by the Republican National Committee. If you think those two cases are unrelated, you're missing the bigger picture. They are part of the same project, a Republican strategy to turn supposedly neutral legal doctrines into weapons, and a Supreme Court majority happy to pretend its partisan choices are just the inevitable logic of the law. Let's start with California. On paper, this is a case about whether the state can use a new congressional map that voters approved last year, a map that's expected to net Democrats roughly 5 more House seats. California Republicans, backed by the Trump administration, ran to the court at the last minute, demanding that the justices step in and freeze the old map in place while they litigate claims that the new lines amount to illegal racial gerrymandering. The justices responded with one sentence: no explanation, no dissent worth reckoning with, no honest engagement with what's really going on. Just a flat denial of the request and a green light for California to use its new pro-democratic map in 2026. That one-sentence order is expected to shape control of up to 5 seats in the House. If this sounds familiar, it should. Just 2 months earlier, the same Republican-dominated court allowed Texas to move forward with a brutally skewed Republican map projected to deliver as many as 5 extra GOP seats, despite a lower court's finding that the Texas map likely discriminates on the basis of race. In Texas, Republicans rewired districts to squeeze non-white voters into safe GOP territory, or pack them into a handful of sacrificial blue districts, and the court looked away. In other words, the court is now in the business of blessing dueling partisan arms races that Republicans started. Texas Republicans redraw their map to squeeze out a handful of new seats. California Democrats respond with a map of their own. And the Supreme Court nods politely in both directions because it doesn't dare admit that the real villain is the GOP's decade-long gerrymander crusade. The court does this while clinging to a line it drew a few years ago, that partisan gerrymandering as opposed to racial discrimination is basically none of its business. You can draw maps that are grotesquely skewed toward one party, they tell us, and as long as you avoid saying the quiet part out loud about race, the federal courts will likely stand aside. That hands-off doctrine just happens to lock in the exact structural advantages Republicans designed over years of ruthless map drawing in state after state. So California defends its map by saying, "We did this for partisan reasons, not racial ones." Texas says the same thing in reverse. And the conservative majority that once professed horror at judicial interference in elections suddenly becomes very comfortable using its shadow docket to decide, in practice, which partisan gerrymanders will govern the next midterms, while pretending it's above politics. Think about how twisted that is as a model democracy. We have effectively outsourced control of the House to a series of late-night orders from a court built by Republican presidents, fed by the Federalist Society, and cheered on by the same party that spent years rigging state maps and now pretends to be the victim when one big blue state finally fights back. Now zoom in on what this actually looks like for voters in California. They went to the polls last year and approved a ballot measure ratifying the new map, one championed by Democratic leaders as a direct response to Texas's aggressive GOP-tilted redistricting. Governor Gavin Newsom presented it as a way to offset Republican gains in other states, a kind of minimal self-defense for people who are tired of watching one party game the system, while the other insists on playing fair. Republicans cried foul and claimed the map relied improperly on race. A lower court looked at the record and concluded that no, this was standard partisan power politics, not a racial scheme. So in the case at the Supreme Court, the justices faced an awkward choice: treat California differently than they had treated Texas, or admit that what's good for one side's partisan map should be good for the others. They chose the latter, not because they suddenly discovered a love for fair representation, but because the legal framework they built to shield Republican gerrymanders now forces them to stomach Democratic counter-moves too. When you insist that partisan line drawing is beyond the reach of federal courts, you are stuck accepting both kinds of maps, even if that means accelerating a race to the bottom that Republicans started and still overwhelmingly benefit from nationwide. This is what neutral doctrine looks like when it's written by ideologues. The court says in the abstract that it's just applying the law, just refusing to police partisan gerrymanders. In reality, it is actively shaping a world where the only way to survive is to gerrymander as aggressively as Republicans do, and where voters are told to be grateful that they still get to show up and color inside the lines someone else drew. Notice what's completely absent from this story: voters. The people whose communities are sliced and diced, whose representation is decided by consultants and map drawers and partisan lawyers. In California and Texas alike, the real election already happened, in a Republican-packed state house, in a courtroom, and finally at 1 First Street, months or years before anyone votes in November. But maps are only half the equation. The other half is which ballots actually get counted. And on that front, this same court is about to decide something, arguably even more obscene: whether states can continue using common-sense grace periods for mail-in ballots, a practice that directly affects millions of military and overseas voters, and which Republicans are attacking precisely because those votes are harder to control. Here's the issue in plain language. Right now, about 30 states, plus D.C. and several territories, have laws that say if your mail ballot is set by Election Day and arrives within a certain window, maybe 3 days, maybe a week, it still counts. That buffer matters enormously for people in war zones, on ships, in diplomatic posts, or just living and working abroad. People who are already jumping through hoops to register, request a ballot, and get it back in time. A federal appeals court in a case out of Mississippi decided to blow that up. It read older federal laws that said a day for the election as if they meant a day for the receipt of every single ballot, and concluded that states had no authority to accept late-arriving ballots, even if they were mailed on time. That ruling did not fall out of the sky. It grew straight out of the Republican obsession with shaving down the vote wherever they can outright suppress it. Now that ruling is in front of the Supreme Court in a case called Watson v. Republican National Committee. Note the name on the other side of the V. The RNC is the one asking the justices to wipe out grace periods that have existed for generations, not because the rules are broken, but because they sense a partisan edge in tightening the screws on the hardest-to-reach voters. If the court affirms that decision, the fallout will be massive. Grace periods that have been on the books since the Civil War and others enacted with broad bipartisan support over decades could vanish in one stroke because Republicans decided their power is more important than their own rhetoric about supporting the troops. And the people hit hardest would be exactly the voters Republicans love to drape themselves in during campaign season: service members, their families, and Americans living overseas. Former military leaders, diplomats, and overseas voters have already warned the court what that would mean in practice. When your ballot has to cross continents and oceans, navigated by lumbering postal systems and military logistics, arrive by election day or else isn't a neutral rule. It's a quiet way of saying your vote is expendable if it's inconvenient for Republican election night narratives. Congress understood this when it passed laws like the Uniformed and Overseas Citizen Absentee Voting Act and the Military and Overseas Voter Empowerment Act. Those statutes explicitly acknowledged state ballot receipt rules and were written against the backdrop of existing grace periods. In other words, the federal government looked at these rules and effectively said, yes, this is part of how we protect the franchise for people we've sent far from home, until Republicans decided those voters were collateral damage in their legal war over counting rules. Now, thanks to the Republican National Committee, the court is being urged to reinterpret those same federal laws as a weapon against grace periods. What used to be a floor of protection is being reframed as a ceiling that states cannot exceed. And once again, this is all being marketed as neutral. A simple effort, we're told, to enforce the day of the election, as if the calendar is more sacred than the people whose ballots are stuck on a C-17 somewhere over the Atlantic. Here's the thing. None of this is neutral, and Republicans know it. The people who sue to end grace periods know exactly which voters they are targeting. They know which ballots tend to arrive inside those extra days, which communities rely on that cushion, and which party's provisional lead on election night could evaporate or solidify depending upon whether those envelopes get opened or tossed. So put these two stories together. On one side, you have a Supreme Court that shrugs at aggressive Republican gerrymanders in places like Texas, then reluctantly tolerates Democratic countermap in California because its own doctrines leave it no alternative. On the other, you have that same court entertaining a Republican plan to strip away long-standing protections for late-arriving mail ballots, disproportionately hitting voters who, by definition, already have the hardest path to participation. The through line is simple. The real elections are being held in courts that Republicans spent decades capturing. Control of the House is increasingly determined by which GOP-favored maps survive emergency appeals and which GOP-sponsored theories about ballot deadlines win votes on the Supreme Court. And the actors driving these cases, state Republican parties, the RNC, Federalist Society alumni, are very comfortable telling you this is just process, just housekeeping, just neutral rules about lines and deadlines. Both parties now are forced to operate on this terrain, but only one party built the terrain this way. Democrats in California are openly pitching their map as a defensive move against Republican gerrymanders the court has already blessed. Republicans backed those gerrymanders, then turned around to attack California, and are now pushing a theory that would kneecap grace periods in dozens of states where close races could hinge on late ballots from voters they find less useful. And the court, the institution that could, in theory, set clear democracy protection rules, is instead acting like the GOP's favorite referee. It insists it's just calling balls and strikes, even as it decides which side's pitches count as legal and which bats get taken out of the other team's hands. What makes this so corrosive is that it happens off stage. Most people don't read one-sentence orders on the court's emergency docket. They don't follow the technical fight over whether the phrase "day for the election" means a day to vote or a day for all ballots to be physically in the building neatly sorted for the convenience of party lawyers. So by the time the election actually happens, the battlefield has already been landscaped to Republican specifications in much of the country. The districts are drawn, the maps are locked, the rules for which ballots count are baked in, and the margins for error, the grace periods, the drop boxes, the backup plans have either been preserved where Democrats managed to win or quietly stripped away where Republicans did. Then when the results come in, Republicans point to the scoreboard as proof of legitimacy. They talk about the will of the people without mentioning that they spent years carving up the people into districts engineered to produce particular outcomes, and that some slice of them, often the ones furthest from home or living abroad, never get their votes counted into the pile in time. Here's where we have to be very clear. Democracy is not just about what happens on Election Day. It's about who draws the maps months before, who writes the rules for counting ballots, who gets to sue when they don't like those rules, and which judges, most of them handpicked by Republican presidents, are willing to invent or ignore doctrines to get to the outcomes their movement wants. When this court says it can't touch partisan gerrymandering, it is making a political choice that overwhelmingly protects Republican-drawn maps. When it blesses Texas's map and shrugs at California's as an afterthought, it is making a political choice about which arms race it's willing to tolerate. When it decides whether to uphold or kill ballot grace periods that have existed since the Civil War era at the RNC's urging, it is making a political choice about whose votes are disposable. If you care about fair elections, you cannot afford to look away from that or to pretend this is some symmetrical, both sides mess. You can't just tune in on election night and assume the story starts at 7 p.m. Eastern with the first returns. The story starts with Republican-driven cases like these, with briefs that almost no one reads, and docket entries that never make it into the chyrons. So what do we do with that knowledge? First, we tell the truth about how power actually works and who is abusing it. We stop pretending that maps are just technicalities and mail ballot deadlines are just calendar housekeeping. And we name them for what they are. Tools Republicans have sharpened for years to shape the electorate and preload the outcome, and tools Democrats are now forced to use just to survive. Second, we stop letting neutral doctrine lull us to sleep. If a rule predictably advantages one side, one type of voter, one set of district, it isn't neutral, no matter how bloodless the language. Ending grace periods for ballots that are mailed in time but trapped in a military mailbag is not neutral. It is a conscious Republican project to narrow the electorate, and a Supreme Court willing to humor it is not neutral either. Third, we recognize that any serious democracy reform has to deal with the court itself. As long as 9 justices, 6 of them placed there by Republican presidents, under a long-term plan to capture the judiciary, can rewrite the rules on an emergency basis with no explanation, you will never have fully democratic elections. You'll have rituals of voting layered on top of a constitutional reality where the real decisions are being made behind closed doors in language designed to sound apolitical while it locks in minority rule. And finally, we remember that shining a light on this process is itself a form of resistance. The more people understand how these cases connect, how a California map, a Texas map, and a Mississippi grace period lawsuit are all part of the same Republican structural war, the harder it becomes for the GOP and the court to hide behind legal jargon and claims of neutrality. So as we watch 2026 unfold, don't just ask who won. Ask what the map looked like before the first voter showed up and who drew it. Ask how many ballots, especially from people serving overseas, never made it into the count because the Republican Party decided those votes were expendable and a Republican-built Supreme Court agreed to help enforce that decision. Because that's the quiet battlefield where our democracy is being decided now. Not in the noise of election night, but in the silence of court orders written by justices who owe their seats to the same party that benefits from the map's reality and demands something better. We're not living in a democracy that chooses its leaders. We're living in a system where Republicans and their court choose the electorate first and let the rest of us argue over whatever's left. This has been America's Fractured Politics. Remember, keep up the fight.